The case is being recorded.
Good morning. Welcome to the October 8th, 2024 sitting of the Massachusetts Appeals Court. Our panel today consists of myself, Justice Eric Neyman, Justice Sabita Singh, and Justice Robert Toone. Calling our first case 23P1202. This case is partially impounded. We will hear first from the appellant. Good morning.
Good morning. May it please the court. I'm Dusty Button and I'm representing myself and my husband. Before I speak freely, is there anything that I can clarify that is within our briefs?
No, to be clear, all the members of the panel have read the briefs. We've read the record appendix, and we are familiar with the legal arguments and with the facts of this case. So please cut to the heart of your legal argument.
Okay. The reason that we filed the motion to vacate is because in 2021, the plaintiff filed a civil lawsuit against us in the District Court of Nevada for $21 million. Without convoluting this appeal with the motion practice of that litigation, we received documents and discovery from the Appellee's Nevada Council in 2022, which the plaintiff included the plaintiff's 2018 affidavit from the Boston Municipal Court. We were never in possession of that affidavit prior to 2022. That was submitted unsigned and unwitnessed to the Boston Municipal Court, as stated in the brief. We were never given notice of that, and we also contacted our attorney, our previous attorney, Kevin Mahoney, and he was not given notice either, which is why he was not present at the 2018 hearing. It was held ex parte, which is where the abuse prevention orders were granted permanently. We also lived in Los Angeles at that time, so we weren't mailed notice. We just received orders that it was granted permanently. And we did not have the transcripts from that hearing or the affidavit of the plaintiff. So
may I ask you a question, please? I'm sorry. Go ahead, Justice Singh.
I just wanted to clarify, you were present at the 2017 hearing?
Correct. Yes.
And at that hearing, it was indicated that the order would be extended for a 1-year period of time, and the next hearing would be in 2018. It
was announced out loud, but we were never given any paperwork or anything like that. The notification of an ex parte hearing, which from my understanding typically occurs, and we were out of state. We had moved out of state prior to the 2017 hearing, and our attorney also was not given notice of the ex parte hearing, and we were not sent a copy of the affidavit for 2018. So we just were never aware or had any reference to the transcripts, which included some of the fraud on the court that we discovered later after reading those transcripts and contacting law enforcement. So that's what occurred in 2018. Sorry, should I continue?
No, sorry to interrupt you. I have 2 questions for you.
Yes.
The first one is, the permanent order entered on August 14th of 2018. Is that correct?
That's correct.
And you stated page 19 of your brief that you were notified of the permanent order months later in California.
Correct.
How many months later, if you recall?
If I recall correctly, it was 3 months later.
Okay. And at that time, did you file a motion to file a late appeal or anything of that nature, to file a direct appeal?
No, we didn't file anything. And to be honest, not that it matters legally, but I think in general, it's so shocking and we have no experience until now with anything legally related to this case. And that was 4 years, 4 years later, we finally had no choice to have experience with the sort of legal issues. Because we have been pro se in Nevada for 3 years, and I don't want to, bring that into it, but that is what occurred. We didn't file for an appeal in 2018, but we also were never able to cross-examine or argue our side in 2018 regarding any of the false allegations, the false police reports that we received in 2018 due to our own due diligence, because we were issued subpoenas to be able to subpoena the police departments. So we were never able to argue that those allegations were false. And basically, when the police reports were given to us, we saw that there were allegations in those reports and that the police found almost all of them stated the exact same thing, that all of the allegations were unfounded based on evidence that they viewed, which were the text messages between us and the false statements that the plaintiff's father made to the police departments, which was over 7 different false police reports, at least, that we know of. And because we weren't able to argue that, we were never able, because it was ex parte in 2018, we were never aware of that information that was given to the court, which fully credited her testimony at that hearing. So they used the reports to say that they filed reports, which obviously sounds terrible, but the allegations in the report were all found unfounded. So had those reports been given to the court, and had we been able to argue that, I think the outcome would have been entirely different. And that was the point of filing the motion to vacate, is because when we received those reports and we received the perjured statements, we immediately filed the motion to vacate. Judge Lyons saw that we had that evidence. She gave us the opportunity to then speak on that again. But the problem was, as soon as we entered into the hearing with Judge Key, he said that he did not want to hear about anything prior to 2018, which I understand in a typical 209A abuse prevention order. This isn't a typical situation. And the problem was all the fraud that we received and all the false police reports were in those years that he didn't allow us to speak on. So
can I ask you something? The motion that was filed, it's a form document, but what was filed was a motion to, I think it was to modify or terminate an order. So the motion asked to modify the order or to terminate the order, but it was not a document to vacate the restraining order.
To my understanding, which obviously is not the experience anywhere close to what you all have, Judge Lyons affirmed that we filed it properly and that we were filing a motion to vacate. So this is the first time that I'm hearing that that is not the case. So we were filing to terminate the restraining order. We actually wanted to file one against the plaintiff, but we were told that mutually you can't do that if you didn't do it in the beginning.
The thrust of your argument was that the entire restraining order was obtained by fraud on the court.
Correct.
Was the commissioner of probation involved in these proceedings at all?
Not that I'm aware of.
So let me ask you another question. I just want to make sure I understand the universe of the fraud on the court claim.
Yes.
So your contention is that the fraud on the court consisted of the failure to provide the following documents. Number 1, a copy of the police report and affidavit, or police reports and affidavit, and also a copy of the allegations that were contained in the Nevada civil complaint. Your contention is that among that universe of documents, there's information in there that contradicted the plaintiff's representations to the court. Is that correct?
That's correct. And I just want to make sure I understand. There was no copy of the allegations in the Nevada litigation that we did not receive. We found out about that.
Well, I think your point was you hadn't received that information back in 2018. You didn't have it back in 2018 or 2017. That's
correct. Yes.
Okay. All right. Thank you.
And also, I was just going to state, just in regards to the briefs quickly, I know, I don't know how much time I have. 6 minutes. Okay. The plaintiff and the lower court continuously referenced the McDonald and Caruso case, which I've read through numerous times, and I hope that you understand our legal advice comes from Google. So I might be wrong in stating this, but from my understanding, that case is significantly regarding a change in circumstances, which is usually what you have to prove when you're trying to vacate a 209A. The problem is with that case, there were no significant changes in circumstances that we needed to prove because the 209A should never have been granted in the first place because the plaintiff was never abused. A large portion of what they argue in both Nevada and now in Boston, which Ms. Mariella was not present for the fraud that took place, which was why we filed that motion to remove the pro hac vice status, which she's in good standing. So I understand why that's not maybe appropriate or was the wrong filing. But Mara Melcher was the representative that did commit a majority of that fraud on the court, which includes the perjured statements. But in quoting that case, there is no instance of fraud on the court. So we can't change circumstances that didn't exist. The only circumstances that have changed significantly is that, say, the plaintiff, apologies, has filed a civil lawsuit against us in a separate forum using this fraudulently obtained 209A as the grounds of her civil litigation 4 years after a permanent restraining order was issued with evidence that we never knew existed. So the problem is getting someone to understand and not view the evidence, but to understand that because the fraud took place so many years ago and we did not discover that fraud because it was undiscoverable, now we have no choice but to go back and resort to the underlying issues. But it's not the same underlying issues as if someone who would be trying to vacate a typical 209A. So if the court stated on May 27th, Judge Key stated, if we start getting into things that have testimony about what happened prior to 2018, I'm going to strike it. So even if we were trying to get the point across at the very end of that hearing, he struck it. So we were never able to actually address the fraud, which Judge Lyons gave us the opportunity to address. And that was honestly the first time that we felt like someone was hearing us, because if from start to finish, someone actually views all of the evidence and now the contradicting allegations in Nevada, which completely contradict the actual restraining order, which has now been admitted was forged and not even written by the plaintiff. And that's another something that I wanted to address, is that we have since deposed the plaintiff in Nevada, but 5 months after we filed to vacate the order. So now we have a 7-hour deposition, which affirms the fraud on the court, which we couldn't submit because the appellate court doesn't accept new evidence when you're appealing something that took place. So we're now in a position where not only did fraud on the court take place in those years, which we discovered 5 years later, we're now in a position where more fraud occurred and is continuing to occur in Nevada. And we're trying to keep up with the process in resubmitting new evidence and proving that none of this should have ever taken place. We should have never been prevented from abuse. We've never abused anyone. And so, you know, it's been a very frustrating situation, but I only have 1 minute and 30 seconds left. But if there's anything else that that I could clarify in that minute, I'm happy to do that.
I just have if you could explain without getting into the details,
Yes.
How is the 209A order in Massachusetts being used against you in the Nevada litigation? I'm not sure I understand that.
So two things. They're using the abuse prevention order as a grounds to state that the allegations in Nevada must be true because she already was granted permanent restraining order in Boston. So it's basically being used as laid grounds to state that there is no falsity to our claims. And they continuously use the statement from Judge McKenna stating he fully credited her testimony without ever addressing any part of the other parts of the transcript. So then the Nevada court is, of course, going to listen to attorneys from Boyce, Schiller, Flexner, who never lied to the court. In addition to that, they state that we violated the abuse prevention order multiple times, but Judge Lyons already stated that we were never in contempt of court. We never violated the abuse prevention order. that any YouTube videos that we did not make that contain evidence proving that the plaintiff was lying, that is being used against us, and we were already sanctioned for something in Nevada that Judge Lyons then stated 4 months later we weren't in contempt of court of. So it's just constantly being used against us. But we will make sure that, the truth is exposed at some point.
Thank you.
Thank you very much. We appreciate your argument, and we will now hear from counsel for the appellee.
Thank you. May it please the court. So this is an appeal of a motion to vacate 2 permanent abuse prevention orders against the defendants that the plaintiff was granted 6 years ago. The plaintiff was granted those abuse prevention orders after a full and fair 2-party hearing in 2017, where the defendants were not only physically present, but represented by counsel, and had the opportunity to, and did in fact, extensively cross-examine the plaintiff. After hearing that evidence, the original trial court said it considered all of the evidence, including what the defendants had submitted, fully credited the plaintiff's testimony, and was satisfied beyond a reasonable doubt that her relationship with the defendants met the definition of abuse in every regard, in every way. The defendants didn't appeal, and they didn't even attend the evidentiary hearing held a year later to permanently extend the orders, despite being notified of the date of that hearing in open court and being handed a copy of an abuse prevention order listing the date of the next hearing. Then years later, after being sued by multiple other women accusing them of abuse, the defendants moved to vacate the abuse prevention orders as part of their warpath of retaliation against all of the women who have accused them of abuse.
Would you agree that the thrust of the motion to vacate was that the order was obtained by fraud, and now they had evidence of it that they'd like to present?
So the original motions to vacate, I think that the defendants would agree. Their primary argument was that Judge McKenna didn't view all of the evidence they submitted, and they wanted another court to actually look at that evidence. And then they also made the argument, yes, that there was fraud on the court because the plaintiff lied during the abuse prevention order hearings, which is—
The motion that was actually filed stated that in the text of the motion, fraud on the court, didn't it?
Yes, exactly, yes. But the basis for their argument of fraud on the court was the plaintiff lied, and that's fraud on the court, and therefore the abuse prevention order should have never been granted, and that they also received these police reports later that they claim prove fraud on the court, which I'm happy to get into now if you'd like me to.
Sure, there's a process for vacating an order that was obtained through fraudulent means, right?
Yes, I'm not challenging the procedure that the defendants followed here. I think the procedure was fine. I just think the basis for their fraud on the court argument under precedent is not actually fraud on the court, because the cases in this state say a litigant providing a false allegation or false testimony, even committing perjury, is not fraud on the court. It is a pattern or scheme to deceive the judicial system itself. And the examples the cases give are bribery of judges, bribery of jurors. And there needs to be a pattern or scheme to deceive. Just saying someone is a liar is not enough. Now, most of their fraud on the court argument is based on evidence that they had at the time of the original hearing, including their text messages with the plaintiff, many of which they actually cross-examined her on and Judge McKenna considered. The only new evidence that they say they have that proves fraud on the court is these police reports that the plaintiff filed in 2017 and 2018. And by the way, the Nevada litigation, to be clear, did not exist in 2018 or 2017. It was filed in 2021. And the idea that the 209A order was used as a basis for that lawsuit is wrong. That lawsuit is based on the plaintiff's allegations of abuse, which will
Well,
be—
can I just ask, because I asked Dee this as well, to what extent is the 209A order relevant in any way to the Nevada litigation?
So at trial, I haven't fully analyzed this, but I don't think it would even come into evidence, right? Her testimony will be about the underlying abuse, and a jury will decide if she's credible and if she was abused and if she's entitled to relief based on her allegations. The only reason it's come up so far is because there was a provision in the 209A order that the defendants never appealed that said that they were to, because the plaintiff alleged that they had made a copy of her cell phone, so they had her personal ESI. So the abuse prevention order said, and Judge McKenna took this very seriously, that they needed to turn that over to her and couldn't publish it to anyone. They filed counterclaims in Nevada and a third-party complaint against the plaintiff's parents and some other individuals that they alleged she had been in a relationship with before them, and attached text messages that we alleged came from the copy of her phone that they had, which indicated to us that they had not complied with the order. So we filed for sanctions in Nevada, and the Nevada court agreed that they're attaching those text messages to their complaint on the public docket was a violation of the order. And they submitted declarations that they submitted declarations at some point in the Nevada litigation, and I can't remember why, basically explaining that they still had this copy of the plaintiff's phone on their computer, and they found it when they were trying to respond to the Nevada litigation. So that's the only reason it's come up so far and why the defendants have been focused on it now, I believe.
Let me drill down on something. Your argument is in part that the information that supposedly came to light later on to the defendants, even if true, does not constitute fraud on the court. I understand that. But let's just assume, and this is just a hypothetical, assume that 5 years after a restraining order issued, information came to light that, as a matter of fact, proved that the prior allegations were indeed false. What remedy does a defendant have in that situation?
So I think under the case law, that would still not be fraud on the court.
Right. So what remedy would they have, if any?
So I found cases saying that if evidence comes out later that would just go to impeach the credibility of the plaintiff at an abuse prevention.
My hypothetical was different. Mine was, let's say there's absolute proof, which I know in the real world doesn't necessarily exist, but go with my hypothetical. There's absolute proof that it was procured by fraud. What then? Or by false representations. What then?
I haven't looked into this specific question, but I would think they could ask for a new hearing, or I think there's also a procedure to move to expunge an abuse prevention order, but I haven't looked into the standard for that because that's not what the defendants asked for here in their original motion. But I know those are potential avenues. I'm not saying that they would meet that standard here, but I think those would be avenues to explore.
Okay.
Were they not precluded from even arguing the fraud on the court by the judge saying, I'm not going to hear anything about anything that happened prior to this date?
No, they were absolutely still permitted to make argument and to give testimony about their fraud on the court argument. So even if the trial court's instruction was error, which I don't think it was, I think it just set out the legal standard and was an appropriate instruction to focus the parties on what he could actually consider. Even if that was error, it was harmless because he did permit the defendants to speak about their fraud on the court argument. For example, when DB testified, she said, listen, we're trying to prove fraud on the court here. She said that right away. And then she testified that what they contend are these newly discovered police reports. She testified about that at length. The court didn't interrupt her. He let her testify. He didn't even strike the testimony when I objected to it and moved to strike it. And then the other defendant, MB, was also permitted to make argument in closing about fraud on the court, and again mention these police reports. And if there's any doubt about whether Judge Key considered that, he made clear in his opinion that he did. In the second sentence, I think it is, he says, one basis of the motion to vacate is fraud on the court. There's a whole section on their fraud on the court argument. And the opinion lists out all of the evidence Judge Key considered, including police reports. That's specifically in the list of evidence that he said he considered. And that's at the first volume of the appendix at 96. So the argument that the court's instruction in any way violated due process or prevented them from saying anything they wanted to say is just incorrect. So I just want to go back to the police reports and the idea that these are newly discovered evidence and that they constitute fraud on the court, because again, this is the only evidence that the defendants point to that they contend they didn't have at the time of the hearings. So there was no discovery prior to the abuse prevention order proceeding. So SH had no obligation to disclose anything to them other than what she was going to rely on at the hearing. But despite that, the defendants say this is fraud on the court because she and her counsel engaged in some scheme to hide these police reports from the court and from them because they thought they would hurt that case. But that's totally unsupported by the record here. The record shows that the defendants knew or could have known about each and every one of these police reports at the time of the original hearings. For example, they mentioned this July 27, 2017 Orange County police report where SH reported that the defendants had sent her a threatening message. And the police found that there was no imminent threat to her. But at the 2017 hearing, where the defendants were present, their counsel cross-examined her on that very report. He said, if you were so afraid of the defendants, did you go to the police? And she said, yes, I went to the police in Orange County and filed a police report. I don't have it with me, but I can give you the report number. He didn't ask any other questions about it. He didn't ask her what the outcome was. No one did anything after that. They didn't ask anyone any more questions. They didn't request it after that hearing to bring to the 2018 hearing. They mentioned this May 2017 Somerville police report, but the defendant's counsel actually himself introduced that report into evidence at the 2017 hearing. And that's at volume 4 of the appendix at 57. So they certainly had it. They mentioned these two 2018 Melrose Police Department reports where SH reported what she believed were violations of the abuse prevention orders. But those were discussed at the 2018 hearing that they chose not to attend, and that Judge Key found they knew about after considering their testimony and finding it not credible that they didn't know about it, which is entitled to deference. So the idea that there was fraud on the court because there was some pattern of hiding police reports from the court and the defendants is just wrong. There was no hiding anything. There's nothing that's newly discovered about them. The Wojcicki versus Carragher case from the SJC in 2006 says that evidence is not newly discovered if it could have been obtained at the time of the original hearing. I also just want to briefly say that the idea that these police reports prove that SH is a liar or that she wouldn't have been granted the abuse prevention orders if the court had had them, it's just wrong, and they totally overstate the value of these reports. For example, the July 2017 report where the Orange County Police Department said, you received this text, we interviewed you, we don't think there's an imminent threat to you at this time. They say this proves that she's a liar and that if the trial court had the police report, he would have found no abuse prevention order necessary. But that's totally wrong. We've all seen cases where a victim of domestic abuse tells the police they're not in danger when they are. That's what happened here. It doesn't make her a liar. It doesn't make her a perjurer. And it's certainly not fraud on the court. And even if he had that police report, Judge McKenna still would have had to evaluate for himself the evidence and whether an abuse prevention order was necessary at that time. He wouldn't have just simply relied on one California police officer's finding about whether she was in danger 2 months earlier. I have 1 minute, and I just want to point to one decision where the defendant made a very similar argument in trying to get an abuse prevention order expunged. That's Brady versus Brady, which is an opinion from this court in 2013.
Expunged or vacated?
He tried to get it expunged on the basis of fraud on the court. He alleged that, so the defendant's wife got the abuse prevention orders based on an allegation that he sent her threatening letters, but she didn't produce the actual letters at the time of the hearing. He ended up getting the letters later and said, according to him, that they weren't threatening, and if he had them, she never would have gotten the abuse prevention orders. The court rejected that fraud on the court theory outright, said you didn't appeal, you can't get around that by just saying this is fraud on the court because you have this evidence that would have harmed the plaintiff's credibility. And it's nowhere near enough to prove fraud on the court here, but that's exactly the argument the defendants make. Thank you.
Thank you. Thank you very much. Let me just check with the other justices. Any further questions? Seeing none, thank you both for your arguments. Thank you for your briefing, and the case is submitted. Thank you.
Thank you.